Our first panel is brought to us by JAMS. It is Planning for, Preventing, and Resolving Privacy and Cybersecurity Challenges. And to introduce the panel, I'm going to introduce Jerry Cohen. Jerry is a mediator and arbitrator at JAMS and a practicing attorney in the area of intellectual property. And Jerry's going to say a few words.
Thank you, Susan, and good morning. This whole day, being close to Halloween, seems like a film festival of horror movies because they're talking about the various crises, some of them being existential crises for a company. Our panel today is going to explore the crises in the areas of privacy and data security, or particularly cybersecurity. There are many forms of security besides cyber, including human error, human venality, and the like, what to do before a crisis and hopefully avert it or mitigate its effect, what to do during a crisis responsibly, and what to do after the crisis by way of mitigation steps and promises to do better, which can possibly lead to a non-prosecution agreement, possibly reduce the damages and PR impact of a privacy breach or a cybersecurity failure in many realms, for-profit companies, not-for-profit companies such as hospitals, and even law firms. There are studies over the last few years showing that law firms are the weak underbelly of corporate cybersecurity and the like, and law firms are doing their best to catch up and get with it. Companies are vetting their law firms for proper practices. So to help us, we have a panel of experts, starting with Heather Sussman from Oric, Hetherington and Sutcliffe, known as Oric or Oric.com, 2 R's.
Not the vacuum company.
And Rob Martin from Partners Healthcare, Melanie Conroy of Pierce Atwood, and Peter Rosen of JAMS. In Peter's case, it's bringing in the dimension of insurance, and I'll say a little bit more as we begin. But starting with Attorney Sussman, she's the global co-chair of Oric's Cyber Privacy and Data Innovation Practice and the leader of Oric's Boston office. And then welcome to Boston for Oric and many other national and international firms here. She's ranked by Chambers USA and the Legal 500 as a leader in this field. I'll not to intrude on her time, I'll just let her talk a little bit more about her relevant experience and the issues that we should be on the lookout for. Heather?
Great, thank you. So I lead the advisory side of the practice, and that means I help companies prepare, plan for, and respond to privacy and cybersecurity requirements, legal requirements around the world. So I represent multinational companies, and it's everything from hiring outside white hat hackers to perform penetration tests on the company. We call those red team exercises. Sometimes you have purple team exercises. There's a whole industry around that. Modeling and simulating cybersecurity incidents before they happen. And so in order to identify any vulnerabilities that the company may have, address those vulnerabilities, and hopefully reduce the likelihood that those vulnerabilities would be exploited later. So are we going to go across and do all introductions for now, or do you want me just to launch in with just begin talking about our topics? I think we should go down the line and just have everybody set the stage. What do you think?
Sure. Okay. I'm Rob Martin. I work as a senior attorney in the Office of General Counsel at Partners Healthcare System. I have been at Partners for 15 years. My background before going to Partners was not healthcare at all. I was a corporate transactional attorney doing lots of tech startup work and middle market M&A work. And then in the late 90s, I went in-house as the first attorney at a venture-backed software company. So I was swimming in technology transactions, and when I came to Partners, that's what I was brought in to do. Partners has a gigantic IT operation. At the time, there were over 1,000 people working in software development and software projects at Partners on the clinical and administrative side. And that's what I began doing, and stepping into projects like our electronic medical record system rollout and big
Small
ticket
projects.
Yeah, that ended up becoming my pull into the cybersecurity side. Joined Partners at a time when HIPAA security was was starting to be implemented at partners. Cybersecurity questions came up, and so no one in the office wanted to touch them. So you call the person who has computer or IT somewhere on the resume, and next thing you know, you're a cybersecurity lawyer. I do day-to-day guidance, program structuring, incident response, dealing with regulators, and then trying to deal with new regulations coming down the pike that potentially can impact partners, GDPR, CCPA, those types of things as well.
So I'm an attorney at the law firm Pierce Atwood, and I'm a member of the litigation and of the privacy data security groups. And, my background and experience is in, all the forms of litigation that can surface, in particular after either an incident or an issue that particularly touches on privacy and data security. So I've experienced in consumer class actions, and securities class actions, and shareholder derivative actions, focusing on director duty and officer duties, as well as in investigations, enforcement actions, and litigation arising from M&A transactions, all of which I'll get to later when we talk about trends in litigation. Now we're seeing increasingly, dominated by those types of litigation, focusing on data and privacy and security issues.
Peter Rosen. I joined JAMS earlier this year after retiring from Latham & Watkins, where I headed the firm's insurance recovery practice. I represented policyholders in litigation, advice about insurance, and structuring insurance programs for corporate and public and non-profit companies for almost 40 years. And I still teach insurance law at USC Law School in Southern California. I'm from Los Angeles, and I'm based in the JAMS Century City Resolution Center. And maybe not surprisingly, since I joined JAMS earlier this year, I've mediated a remarkable number of data breach, cyber risk, consumer protection that are based disputes that arose out of data issues, all of which we're going to be discussing in the next hour.
Before we turn to Heather, let me just say, you've just seen the tip of the iceberg of these panelists. I have 4 or 5 pages, CVs of them. So just go to the Pierce Atwood website, the ORIC website, the JAMS website, and in Rob Martin's case, a robust LinkedIn profile as well, because there's so much more interesting to see about all of them. But with that, let's turn to the substance. Heather?
Great. So Rob and I wanted to kick off talking about planning for a crisis, because in some ways, the best defense is a good offense. I don't know what's the right butcher of sports metaphor, where planning, and then planning some more. So we're going to talk a little bit about that and about strategies, but really a lot of that is driven by what we see as a shifting privacy and cybersecurity landscape. Now, traditionally in the United States, we've had a big focus on cybersecurity, right? The breach notification laws from the early 2000s that we saw starting in California and sweeping its way across the country, where today we have 50 breach notification laws where you have to proactively notify someone when their personal information there's been unauthorized access, acquisition, in some cases it's loss of their personal information. What's interesting though is that only about half of those states proactively require companies to protect that information. And they say you need to have reasonable administrative, physical, and technical safeguards. Some states, like Massachusetts, get a lot more granular, and they provide under 201 CMR 17 a whole series of steps that you need to take designed to protect personal information, as that term is defined under the state's law. We also, in the United States, traditionally have focused on particular sectors. So the healthcare sector, for example, where we look at what we deem to be particularly sensitive information, so what HIPAA is to healthcare institutions and the protection of health information. A law known as GLBA, the Gramm-Leach-Bliley Act, protects financial information. Interestingly, if you look at both HIPAA and GLBA, they have a privacy rule, they have a security rule, they have a breach notification rule and requirements. So you start to see these themes, right? Privacy rules typically govern the collection, use, transfer, disposal, disclosure of whatever information may be governed by that particular rule. So that's privacy and a privacy requirement. We think of the regulation, whether you can do as a company what you want to do with the information. The security rule typically says, well, if you're going to collect the information, here are the requirements around how you need to protect that information. So security on the one hand. I will often say that you can have security without privacy, right? The NSA might teach us that. Security without privacy, but you cannot have privacy without security. You cannot keep information private without also keeping that information secure. And then the third pillar of these requirements are typically breach notification requirements. So that's the landscape in the United States. In Europe, since 1995, actually we could go all the way back to the OECD guidelines, the Office of Economic Cooperation and Development, which set, again, within these are private industry guidance and requirements that set out what private industry, a set of fair information practice principles back from the 1980s. If you are going to collect information, here are the fair information practice principles around how you need to treat that information. And if you look at the OECD guidelines, each of the fair information practice principles have these concepts of privacy, security. They don't really touch on breach notification.
No, and the one, I guess the one thing that I would add from particularly in the healthcare context, but I think it applies in other industries as well, there's a lot of focus, particularly on the regulatory side, on the privacy aspect, on securing the information. Particularly in healthcare, we worry about the integrity and the availability of it as well, right? So there's lots of the regulatory focus on privacy and security is notifying folks if something happens, right? The biggest issue, or one of the biggest issues that companies in the healthcare space face, is what happens if you can't access the data, right? So if your folks are in an OR and your system goes down, that's a problem. That's not a breach notification problem. That's a real-time patient care problem. Short of the system going down, one of the things that folks in the healthcare space take very seriously and actually plan and figure out how to deal with would be an integrity problem, right? So short of your system going down, what happens if you had something occur with the system and you couldn't trust the data in the system, right? That's almost worse than not having the information at all. If I didn't know that the information I had for Heather was supposed to be X and it was Y, it's almost worse than not knowing what's in there to begin with. So that's another component that you have to deal with, in addition to the regulatory piece that Heather was talking about when you're in the healthcare side.
No, really great point. And I think the reason I'm focusing too on sort of way back from the 1980s, way back when, in the 1980s and the OECD guidelines, is that you even saw privacy and security, these complementary concepts there. Then in the 1995, Europe passed what's known as the 1995 Data Protection Directive. And within the Data Protection Directive, there were similar requirements of privacy requirements, the Fair Information Practice Principles, almost codifying, if you will, those OECD guidelines. So that was 1995, right? And then fast forward to 1996, 1997, we saw HIPAA and GLBA here in the United States. Still, though, it was just health information, financial information. And then it was really the breach notification laws, I think, that were the next proliferation in the United States because breaches were happening so much more frequently. And we can talk about a whole host of reasons of why I think that is here in the US. But that's from the 2000s. And so now what we had most recently in 2008, oh my God, May 25th, 2018, the General Data Protection Regulation, which took many of the principles from the 1995 directive in Europe, codified them in a set of fair information practice principles, security principles, and what used to be a directive that simply directed European member states on how to implement cybersecurity and privacy requirements is now a common regulation that persists across all of Europe. And so what we see under these privacy rules, these fair information practice principles, are this concept. It's a fundamental human right that your information about you, personal information, where in the United States we think about it as health information, financial information, social security numbers, other financial account information that we want to protect. In Europe, personal data that deserves protection under these broad laws are just any information that can be used to identify a natural living person. So your name, a photograph, telephone number, and the like.
Email address, IP address.
Email address, absolutely. And IP address, yeah, device identifier of your phone. So, many practitioners, companies in the United States are looking at this GDPR like an anomaly, saying, wow, those are pretty broad protections as a company. Before the CCPA came along, we didn't have anything similar here in the United States. So fast forward to 2019, and we now have the California Consumer Privacy Act, which many would say is a mini version of the GDPR. I don't think they don't line up perfectly. But some of the concepts that the GDPR codified in Europe, we now see under the CCPA. So most importantly, under the California Consumer Privacy Act, it expands the definition of what is protected information, where the definition under California law, instead of focusing on social security numbers, health information, and the like, it actually defines personal information as any information that can be used to identify a natural living individual, right? So it's actually very similar to what we see under the GDPR. It codifies a privacy requirements around the collection, use, and disclosure about what a company's information practices are. And then, really interestingly, there's no affirmative requirement to have reasonable security. So under the GDPR, Article 32, you have to have appropriate security controls designed to protect personal data. Under CCPA, it doesn't say you have to have reasonable security. What it says is that if a company has a cybersecurity breach, there's a breach, so unauthorized access or acquisition to personal information, as that term is defined under the breach notification laws in California, then individuals in California consumers can bring a private right of action to the extent that that breach is due to the company's failure to implement reasonable security controls. So the risk now of a private right of action, which we can talk about as Melanie discusses later, but the risk of a private right of action post January 1, 2020 in California just dramatically increases risk for companies doing business there, because the available statutory damages are up to $750 per affected consumer. So that means today in the United States, if you have a 1 million person breach, it's actually pretty rare today that those cases are filed from a litigation standpoint. And if they are filed, they're often dismissed because traditionally you need to be able to demonstrate as a plaintiff that you've suffered harm. And harm in the United States traditionally means economic loss. In a typical credit card breach, credit card companies are making you whole for any losses that you identify on your card, any fraudulent charges, and so you're typically not able to show economic loss, case is dismissed. Once the CCPA takes effect, that $750 per affected consumer damage model means all of those prior defenses go away. And for a typical 1 million person breach in California, the starting point for damages claims in a class action litigation is $750 million. Like, you can imagine the number of plaintiffs, class action lawyers coming out of the woodwork. So what does that mean? That means that companies are saying, whoa, okay, so if I have a breach post-January 1, 2020, a plaintiff can allege that that breach is due to my failure to have implemented reasonable security. So man, I better figure out what reasonable security means and implement that.
And that's actually one of the bigger challenges from the in-house perspective. These conversations tend to happen when you're doing your program planning. I had the good fortune or misfortune of being at Partners when all of this stuff grew up, having joined right around the time that HIPAA privacy was being implemented, security, the stand-up of a formal InfoSec program that's kind of grown over time into its own thing. The challenge that we've seen is you're trying to design the program that A, meets all the regulatory requirements, B, is operationally sound. You can't shut the business down and stop treating patients in order to comply with security requirements. That sort of defeats the purpose. And at the end of the day, also trying to make it a defensible program, because the challenge is when an incident happens, particularly from the regulatory side, the decision or the analysis about whether your security controls were reasonable and appropriate is always made in hindsight, right?
Yeah.
The fact that something happened must have meant that you guys didn't do something that you were supposed to be doing, which is a tremendous challenge, right? You're dealing with, particularly on the technology side, zero-day exploits, those types of things that you don't necessarily have 100% protection for. I mean, even the NSA and the DoD are at risk of compromise for some things. So when you start to see developments on the regulatory side, like CCPA, where you have a private right of action, an amorphous standard, right? You didn't comply with some reasonable security requirement, and then statutory damages up to 750 per person. It starts to make, obviously, it heightens the risk profile internally for the security folks, for the senior leadership, and anybody else that plays in the space. I'm sure the insurers are reevaluating their programs and profiles as
Absolutely.
well. So it's a big challenge to do this stuff and to find the right level of program that meets all the regulatory requirements, appropriately protects your customer or your patient information, and then also is a defensible program in the event something does happen down the road.
And I would say, oh, sorry, question?
Just with regard to small businesses.
Yeah.
That's the huge challenge, trying to figure out what level of security must be put in place. Because noted regulations, noted state laws, the breach statutes. However, what's been developing over time as well are these standards from, courts are looking at the ABA, at ALTA, the American Land Title Association, at National Association of Realtors, and saying to parties, for example, in real estate transactions, hey, listen, if there's a breach of something, you're all got a probability and percentage of liability there. And they're saying because you should have looked at these standards and best practices from these other, so it's like there's this whole, spectrum of requirements, and the question is, okay, well, what do I have to do, and who do I turn to? Would it be you that, like a lawyer like
You were like the
that
best
turn to?
audience plant ever, because that's the next point of our conversation. We
Right.
want to say, we're going to give our tips for what to focus on and what are the areas to look at, and that's, you want to start, or I'm happy?
Yeah, I mean,
Whatever you want.
I guess
Go
I'll start
for it.
with the first response to the question. I think from the regulatory side, the regulations attempt to deal with that by using terms like reasonable and appropriate, right? But they don't give you a lot of technical guidance as to what that means. So it is a huge challenge for smaller entities who don't have an in-house cybersecurity team, right? They'll have somebody who might be focusing on security that's probably the IT person who's probably also doing something else at the same time, right? They don't have a chief security officer. They don't have a bunch of InfoSec analysts. They don't have incident response people, and they don't have any of the sophisticated tools because they can't afford to deploy them to do a bunch of things. So it is a big challenge. It's not just a challenge for the smaller companies. Working for a very large organization, one of the things that we've spent a fair amount of time looking at is the exposure that you may have to smaller companies along your supply chain as well, right? So it's wonderful if we have a security program that's taking care of A, B, and C, but if we have a mission-critical vendor who may not be a large vendor, what would happen if, to use an example from a couple of years ago, I mean, lots of folks were justifiably alarmed and figuring out plans to deal with the ransomware, the Petya and the WannaCry
Still
stuff.
happening.
What would happen if one of your critical vendors, who may be a smaller vendor, without a sophisticated program, is impacted by that, right? How would we deal with it if that happens? And it's a huge challenge. I mean, it ends up being
But not insurmountable.
Not
So I would
insurmountable.
say, here's the focus is people, processes, and technology. First of all, you got to have the right people in charge. If you don't have a chief information security officer or someone who knows security, I think that's vulnerability number one. You need someone who has an engineering background, who understands security to be responsible for the program. And that person needs to have a counterpart, a lawyer, a legal person can help identify what the legal standards are and then map to the legal standards. I hate to say HIPAA is easy. HIPAA is not easy. HIPAA is it's so difficult to move into it. But at least HIPAA, the security rule, will set out required and addressable standards. When you're dealing with what's reasonable security, I would say default to looking to recognize standard. And that's in conjunction with the lawyer and the information security person to say, okay, let's take the NIST cybersecurity standard and let's start mapping our controls to those 17 controls. Another great programmatic approach is the NYDFS. The New York Division of Financial Services has put out a cybersecurity requirement. You may not be regulated by NYDFS, but it's a short read. It's like a 17. No, the SHIELD Act is a breach notification requirement. These are the NYDFS. Just Google NYDFS regulations, cybersecurity regulations. It's like a 17-page document, and it is the forming of a cybersecurity program beautifully. I mean, it's tough to actually comply with when you're, but if you're trying to set up your own internal standard, because that focuses on governance, people, Who do you appoint in charge? How accountable is that person? Do they report up to the board of directors? And what kind of reporting and oversight do they have? Processes. You have an internal set of documentation that maybe maps to your NIST cybersecurity standard. You figure out your 17 controls, and you have your internally facing policy documentation. Part of that is also your incident response plan and incident response planning, designing that.
And that's actually part of the program development as well. It's one of the things that you do when you set up the program is you figure what kind of standards and regulations you need to map to. You know, we've got obviously lots of
And
regulations.
if you don't have any, pick an industry standard.
And pick one, right? So in healthcare, you've obviously got to deal with privacy and security. You've got state law issues. You may or may not have GDPR to the extent you've got some international operations, CCPA coming down the pipe. But you also have to map your program to a standard using the NIST standard or something that kind of guides your policies and procedures in your program development. Part of those policies and procedures is the incident response planning, as Heather talked about. You've got to figure out what the process is when an incident happens, so you're not figuring it out on the fly. It's always hard the first time you have to deal with something because you don't know what you don't know until it happens. But
you got to have a plan.
It's got to be part of the plan, right? It's got to be, if something happens, this is the group that needs to be on the call right away. Here are the decisions that need to be made right away. This is the notification tree that you need in terms of internal folks that need to know about it, external folks that need to know about it. One of the topics that we'll deal with later on is the insurance piece, but if you've got cyber coverage, there are notification requirements in there, and you want to make sure that you've got those in check. You want to make sure that you've got resources lined up and you know who to call if you need some external resources. You don't want to be figuring that out at the time because things tend to be going 1,000 miles an hour when something happens. And once you've got the plan in place, you've got to test the plan, right? So you've got to do the mock exercises like Heather was talking about, right? So we'll game out, what if X happens, right? This incident's happening, it's playing out real time. Who do you get on the phone? And then you can look back after doing an exercise like that and figure out what broke, right? What would we
And I
have
would
done
say,
better?
while you're looking at, so you got your people in place, you have the right processes, you've mapped the particular standard that works for you. You can't forget, and you have your incident response plan that I call it a tabletop program where you're practicing the people to having these mock events and what you do. If your incident response plan isn't being run, your incident response team should be run by a lawyer. You want to make sure that those incidents are being managed under privilege and confidential. So if you're running an incident, you're protecting that under privilege. And then technology, don't forget about technology. If your technology team is your IT, information security team, is continually asking for budget and they're not getting the budget that they need, you're gonna be struggling. And that's in part how the lawyers and the engineers need to work together to say, here's what we think is a reasonable program, and then you make the case as to why the law now requires that you have. It's no longer enough that you think IT or information security is something that we can skimp on. But figuring out, and then how you fit within the marketplace so that you're middle of the pack rather than behind the pack is key. Backstopping it with insurance.
Sure, there's one thing. There's a catch-22 here. When you do have a plan and it's made known to employees and consumers or whoever may be affected, then you get in trouble with the Federal Trade Commission and the SEC for unfair practices by not following your own plan or having created a financial liability that you haven't reported to the stock market here. So don't overpromise in the information security plan, and do not use a template or somebody else's plan. It has to fit your company.
I'm so glad you just said that because we are an organization that assists like law firms all over, the New England area. And one big thing that you hear from the law firms, because we do identify, get the expert attorney, get the expert IT security person to assist to develop your plan. And the response back is, can't you just give us a template? Give us a template of an information security plan, and then we can just, use it. And it's like, well, no, you really have to evaluate individually your operations.
No, but you can start with a template.
You could.
You want to start with a template. You don't want to build these things from whole cloth. They're people who know what they're doing. You start with a template and then you customize it to your operations. Absolutely.
But you utilizing the expert.
Right. That's my point.
You would start with a template or a framework, right? There are policy frameworks. There are NIST-based policy frameworks. There are other, policy and procedure manuals out there that you would use as a starting point and customize to your organization, right? What kind of decisions need to be made, whether tweaks to certain policies need to be made based on the industry you're in or how you operate or how you're set up. But I think most of these programs, and Heather probably knows this, seeing multiple clients versus one, will start with a policy framework that then they dial their own needs versus starting from whole cloth, like she said.
We'll switch where others, but any last comments from Heather? Are you, Rob? A moment, we'll have more later. Okay.
I would
now-
just say, can I say quick, I'm going to give 3 tips for purposes of detecting and responding. We're seeing real-time security incidents today. Multi-factor authentication, that is one. When I mentioned technology, that is one that is becoming clearly the standard of reasonableness. If you do not have multi-factor authentication deployed for web-based access to your network or systems, including Office 365, that's one of the biggest ones. Office 365, most small to medium enterprises, because it's the cheapest version, are selecting a web-based access for their Office 365 email and not deploying multi-factor authentication, either because it's a pain or it's too expensive. But that is the single biggest vector of attack that we're seeing, where credentials, employee just clicks on the fish. They're so good at getting your employees to click on those emails and enter their credentials. I just got one yesterday. I just forwarded it on to the security department. Right? So multi-factor authentication cuts off that vector of attack and saves you as a company a disastrous result. The other issue that we're seeing is if you are a company that uses a GitHub server, GitHub to store your source code, you might say, oh, all of our assets are encrypted, I don't have to worry about it. Well, most companies actually store their source code in the GitHub server, and the encryption keys in the source code are stored in clear text. So the attackers have figured that out. They try to get into wherever your source code may be stored. They grab your source code, harvest the encryption keys, and then they can instantly move laterally through your company because they've got the keys to the kingdom. So figuring out where your source code is, whether you have clear text encryption keys, and making sure that, talk about defense in depth, that's the stuff you want to really protect and put your deepest layer of security around so that the attackers can't get at it. And then the third thing that I would say is just plan, and plan some more. These tabletop exercises can help you identify those kinds of vulnerabilities in advance and go such a long way. If you have a breach, for you to be able to say to a regulator, we had 4 tabletop exercises this year. It's amazing how much that starts even within the organization to raise the level of awareness on security and help reduce the risk of liability.
Okay. On the technology piece, let me say that what is adequate in a 4G era may be inadequate in a 5G era, so you have to update to follow the technology to be reasonable. And in a few years, when we have quantum computing, it's a 1,000-fold or to 10,000-fold difference in ability of hackers, and there'll have to be an equal ability of protection to good guys versus bad guys running to a high level. Yesterday in the Times, it was reported that a quantum computing experiment was made that was equivalent to the Wright brothers' first air flight over Kitty Hawk. It was only 3 minutes, but it proved that the era of aviation was at hand. They say that this is comparable. Microsoft, Google, and others IBM are competing in this area, and it's coming along. And the equivalency would be that if the jump from 4G to 5G is a hockey stick, an improvement, but not much in aviation, the quantum computing is the real aviation era that's coming up. So turning to what happens in the crisis with all of the preventive medicine you've just heard, I'll turn to Peter Rosen about the insurance company. Insurance will take care of it, right?
I wouldn't go that far, but it's definitely looking at and examining your insurance program, your client's insurance program at the front end will help your clients and your companies to deal with a cyber risk event. And the insurance is truly a part of the plan. It has to be considered as part of the plan. And in fact, if you don't focus on your insurance on the front end, you're going to find there are a lot of holes in what you thought might be available from an insurance perspective in mitigating the effects, the financial effects of a cyber risk event. For example, most folks think your general liability program may cover a cyber risk event. Don't count on it. The standard general liability policies now typically exclude most cyber risk events. And some folks, particularly smaller businesses, will buy an endorsement that might cover some cyber events, but usually the limits are very low and the coverage is very limited. Maybe their property insurance program might cover from damage to their computers, physical damage to their computers because of a cyber risk event, but there's got to be physical damage. If there's just a loss of data, that might be property in everyone, in the lawyer's view of the world, but that's not property typically for insurance purposes under your property insurance policy. If you're engaged in financial services and you have a bond, a fidelity bond, that may cover any cyber computer fraud events that emanate from a cyber event, and you've lost some money or you've had some money stolen. But again, there are limitations under those policies for cyber risk events. If you're a law firm or you provide professional services and you happen to have your client's data and you suffer a data event, a breach, there may be coverage under your professional liability program for any losses your client suffered because of their data that you're holding in your system. But again, don't count on it. A lot of law firms, for the privilege of doing work with iBanks, must indemnify those iBanks, investment banks, against all losses they may suffer because of a data breach on your system as a law firm. But there are limitations under your E&O policy, your malpractice policy, for those indemnity obligations. The boards of public and private companies may be exposed to cyber risk events, but again, there are limitations on what's covered under those policies in the event of a cyber risk event. So what are the insurance companies now doing to deal with all of that? They're trying to silo everyone's cyber risk in cyber policies. Unfortunately, there's no uniformity among the 200 or so offerings that there are out there these days for cyber risk. There are cyber policies. They cover both first-party losses, so any losses that you, the company, have suffered because of any data breach, but that first party, those losses typically deal with liability that you folks may be exposed to because of a hack or a data breach, but it mostly deals with your costs in dealing with that breach. The policies also cover third-party expenses, so losses that others have suffered because of a data breach on your system. But again, there can be some limitations. So it's important on the front end to get a broker involved who's experienced in handling and placing cyber risk programs so they can help you design, or your clients design, a cyber risk program that works for you folks. And then on the back end, the key is notice. It's if you get a claim, no matter how insignificant, if you have an event, no matter how insignificant it may be, you've got, you may think someone got into your system and you might have to do a software upgrade to deal with it, and your provider's giving you the information that you need and the patches you need to prevent that event from happening again. Typically, most companies don't report that to their insurance company, even though they have some form of cyber program. I've already mediated 2 cases this year where, of course, the insurance programs, the insurers change from when that first incident occurred, and the insured did not report that event to its first insurance company. It either renewed its insurance program or got a new program with a different insurance company. And of course, there was a major event under the next insurance company's program. And of course, both insurance companies are pointing the finger at each other, saying, oh, it was in the other policy, or no, which policy did it actually fall in? All because the insured looked at that initial, arguably insignificant event and decided either not to report it to its insurance company under that policy, or it didn't disclose that event in the application it made for a new insurance program with a new insurance company. So your insurers are there to be your partners when anything happens that's cyber related, and you should report it. You bought a contract the contract, you paid for your insurance policy, you paid premium, that's consideration. Take advantage of the program and report the event. They're there to help you, work with your broker. The insurer is going to provide you, as Melanie's going to talk about and Heather's discussed, they're going to provide you with consultants and experts and lawyers who know, lawyers like Heather, who know how to deal with these events, and they're there to assist. So take advantage of the program that you've decided to purchase, the cyber risk program, insurance program, to deal with these potential risks. And so it's planning on the front end. What kind of insurance do you need? What can you afford? What can your client afford? And then don't be afraid to take advantage of the insurance you purchase. Call your broker, call your insurer, give them notice when anything happens that potentially could be covered under that insurance policy you bought, so your insurer can avail yourselves and your clients of the resources that they bring to the table. So I'm going to let Melanie now talk about some of those events.
Could you just mention, Peter, the notion of duty to defend versus duty to indemnify and the reservation of rights?
Sure. So many of these, so to the extent we're dealing with a third-party claim, that is a claim that is brought against your client or your company as a result of a data breach, these cyber risk policies typically will provide your client or you with a lawyer to defend against that claim. And typically the insurer will do so under a reservation of rights. You'll get a letter, your client will get a letter from the insurer advising you that, well, we think this is potentially covered or it may be covered, and we're going to provide you with a lawyer who's an expert in this specific area to defend you or your client against the claim while we're investigating whether it's actually covered. And that's typically done in a letter, and that letter is called a reservation of rights, because the insurer is reserving rights to later either
Claim it's
accept
not
coverage
covered.
or deny coverage, okay? And I won't comment any further about the reservation of rights letter, because there are all kinds of nuances under applicable law about the strengths and weaknesses of the reservation of rights letters.
Okay, thank you, Peter. And now getting to the hardball phase of all this, if all the rest that came before was softball. Go ahead, Melanie.
So, we've been talking about preventing, mitigating risk, immediate response to risk. The particular type of risk that I focus, the most on is litigation risk. And as Heather had mentioned, it's a type of risk that we are seeing rapidly proliferate and expand not just in, the potential magnitude of individual risk in individual litigation by virtue of statutory damages, but also the incidence. It's interesting. So this morning I wake up and one of the first headlines I see is that there's a new report that consumer class actions over the last decade have tripled, and that the driving cause of this are privacy consumer class actions. And that's for a whole host of reasons that I'll get into. So there are different types of litigation exposure. Right now, the headline grabbing type of exposure, well, there's so many, but consumer, is one segment. And that's rapidly expanding for a number of reasons. The first, I would say, would be there's an increasing focus. I think that there's an increasing focus by virtue of using statutes that already exist, like the TCPA, which protects against unwanted communications, or BIPA, Illinois Biometric Privacy statute, that this year there were a number of decisions that, as Heather mentioned, really eroded the potential protection of arguing against harm. And in addition, there's new legislation, so the California Consumer Privacy Act, and now we are seeing legislation proposed across the country. Here in Massachusetts, there's actually a bill pending that would have a CCPA-like statute enacted in Massachusetts. Hasn't passed. It's under committee consideration. But it contains a broad private right of action that, if it was passed, would become the broadest in the country. And so an increasing number of statutes that give consumers the right to bring suit in the event of either a breach, like in California, where they're alleging that reasonable precautions were failed to be implemented, or statutes like the Illinois law and the proposed Massachusetts law, where a technical violation of the statute could give rise to a consumer being enabled to bring a class action suit and seek statutory damages on behalf of every single affected class member. And in those cases, the number of consumers that companies increasingly interact with, or the number of data subjects who might be affected by a breach or a security incident, is large and growing ever larger. And so given statutory damages, the exposure there is enormous. So the other thing that I would note, in addition to this increasing trend of statutes that are being proposed and enacted that are based on GDPR, CCPA, BIPA, our folks are using existing law in new ways to bring consumer class actions. I also would note that a trend that is possible, but I think most commentators think is somewhat remote at this stage, and there's a big push for it, we'll see, is a federal statute at the federal level, because in managing litigation risk, a major concern is that we are now facing a patchwork of legal obligations concerning privacy rights, where it can be by sector, it can be by state, it can be by where your business is located, it can be based on where your consumers are located, your servers are located. It's increasingly complex, it's evolving, at light speed. On a month-to-month basis, you sort of look at maps of privacy law across the US, and month to month, those maps don't look the same, and businesses are expected to keep pace with that. So that is one of the major arguments behind federal legislation that would preempt state law, that would create a uniform, consistent national regime.
To put this in context, in the Central District of California, where I'm from, TCPA cases are in the top 3 of the most filed cases, and those are both individual and class action cases. They're both individual, and they're, because of the statutory damages under federal law, there's just many of the cases, the judges don't have any discretion about how much they're allowed to award or not award in the way of damages. And then very creative plaintiffs are always adding in the state statute, which is called the Rosenthal Act, but is now we're going to be adding the CCPA, and there are attorney's fees elements to that. So the numbers keep going up dramatically, and then you see a fair number of class actions too that are being brought.
TCPA is the Telephone Consumer Protection Act.
Yeah,
It's
right.
robocalling, text messages without consent.
But again, consumer
Faxes.
protection type things. In fact, I just mediated a case involving over 10,000 text messages, and the statutory damages under the federal law, $500, not 500 or less, $500 per text. And the class was certified. Big dollars, a lot at stake, and very difficult to resolve.
Exactly. And so, as you mentioned, we have new statutes to contend with, but we also have, older statutes that are being used in newer ways. So increasingly, in terms of looking at consumer litigation trends, we're seeing right to privacy statutes, Unfair Trade Practices Act statutes that are under state law, among others, that are now being used to allege consumer privacy actions. And oftentimes they're being articulated in a way that there was a legally recognized privacy right by virtue of a different law that doesn't give a private right of action, like HIPAA, FERPA, which affects student educational privacy, other COPPA, child online privacy. And they're saying, okay, there's a legally recognized privacy right here. I had a reasonable expectation of privacy because these laws exist, and that was violated by virtue of information sharing or a security incident, or in Unfair Trade Practices Act claims stating, there was a claim that security measures were robust, I expected rigorous privacy controls, you induced me to enter into certain transactions when that in fact wasn't the alleged case. So you're really seeing this confluence of factors where in the consumer space, you're seeing individual, but especially class actions where the magnitude of potential damages is enormous. In TCPA cases, you saw a $900 million damage assessment in one of these cases. I think that's just going to proliferate because, as we saw from the trends where these consumer class actions have tripled over the past decade, there are new statutes that haven't yet been tested, like in California. The other concern for a litigator like me is that a lot of the newer statutes remove what you would traditionally regard as certain protections or as certain, barriers to seeing the case proceed. One thing that hasn't been well tested, certain statutes now have provisions that purport to invalidate arbitration provisions or class action waivers. I think those will be tested and likely will be supplanted by the Federal Arbitration Act, but it's a concern and it would need to be litigated. And the party that has to litigate that is going to bear significant expense.
I think one other thing that I would add to that that's particular to the healthcare space, and in addition to the conflict between different state statutes or federal statutes and then some of the international things as well, is there are sometimes conflicts between different regulatory agencies in terms of what the priority should be. So we've obviously got a heavy privacy and security focus, both at the federal and state level, in terms of making sure that information is private and secure. But then you've got other regulatory agencies that are pushing a countervailing priority, right? In the healthcare space, you're actually having mandated information sharing, right? It's a huge benefit to patients to make sure that your information is available to various providers. There are rules that were just promulgated to prevent information blocking between providers and different EHR vendors to make sure information flows. There are other rules that came out last year in terms of right of access that patients have to their own information that allows and actually requires you to have your electronic medical record system permit a patient to access their data and basically export it to a consumer device or site or app of their choosing. You can't block it. You can't really do any kind of investigation or analysis of what the site is other than to let the person know that they're doing it. So in one respect, you're concerned about making sure the data is private and secure. You're also trying to make sure you're not running afoul of other federal regulations that would let you be accused of information blocking, that you're not preventing folks access to their own data. And then you worry about at the end of the chain, how do I do both at the same time, right? How do I make, if I really, really, really wanted to focus solely on security, you wouldn't open a window letting folks export the data to a fitness tracker that Heather may have developed in her garage yesterday, right? But you're not allowed to stop that as long as you're using the right interface. So you've got a bunch of conflicting priorities at the same time, and at the same time the litigation risk is going up.
And maybe a potential, making it sound rather doomsday here. And there's a lot of strong defenses that can be used, but the concern is seeing it eroded and will it be litigated at the end of the stage. For example, in the CCPA, where it's a question of reasonable measures, that's a question of fact that is going to be difficult to defeat at the pleading stage. But there's, in the other areas, so outside of the consumer context, there's also been trends of increasing litigation, in securities class actions based on incidents, stock price drops following securities incidents, and also concerning corporate governance. And I think especially I'm going to focus in on the corporate governance. I think there's also some lessons to be learned there that I don't know that we've specifically addressed in that, one, increasingly, so both, there's sort of this groundbreaking, $5 billion FTC settlement with Facebook that made all of these headlines. Billion, yes, with a B. But a lesser known headline, there were some aspects of there that were of particular interest to me. First, there was also a simultaneous or contemporaneous $100 million settlement with the SEC. It signaled how seriously in the security space that these disclosures are now going to be scrutinized, public disclosures concerning data security and privacy practices. But there's also lessons learned, and we're seeing this as well from increasing M&A litigation activity, is that it's a way to bring in those specialists early concerning your disclosures, how they describe these programs and processes, whether it's reps and warranties, whether it is in disclosure documents for offerings, and that we can have lessons learned there. The other is in the Facebook settlement, it was very interesting because there were certain demands made concerning board composition and corporate governance oversight. We're also seeing that a little bit coming out of, Delaware litigation. There's sort of a line of cases of board oversight and responsibility obligations that can give rise to litigation liability. The Caremark standard, which is the director's, duties of care and oversight at the company. A recent case that was really interesting was Clovis Oncology, which suggested that simply saying there is a compliance program the directors sign off on isn't enough. And that was also the message we took away from the FTC's Facebook settlement, which is you need to look very hard at what is appropriate for your organization in terms of board expertise, board education, board composition, and board, how active that board is in their oversight function of security and privacy programs in the company. And that will be different for each organization, but it was a strong signal that hard look needs to be taken. With that said, again, there's sort of a small dose of optimism there in that it does suggest a path forward in, as we've all discussed, how to help guard against risk is taking that hard look now and deciding what is appropriate for the organization.
I'd be interested to hear what Heather had to say, but I think from a board and a governance perspective, I think these issues are becoming more of a focus for audit and compliance committees and the board in general. I think there's a push towards regular reporting on not just programs in general, but specific IT risks, what's going on, what's the oversight, is it dialed in for your industry and best practices in general? I think that's probably a trend that's not going to go away anytime soon.
I'm mindful of the fact that we spent a lot of time talking about preparing for an incident and how to implement a reasonable security program. Then we sort of jumped ahead to talk about litigation and litigation risk, cyber insurance. I'm wondering if it's helpful to talk a little bit about incident response itself, because so much of the actions that the company takes during the process of responding to an incident are actually what set up the insurance disputes or the claims and litigation. So Rob, I'd be really interested to hear from you some tips for managing
going back
those
to
kind of crises.
the preparation and knowing what you're going to do before it happens is the key from my perspective. It's having a plan, having a program, so you know who the players are when something happens.
But a breach happens, right? You get the phone call.
I get the phone call, right? So I'm the unlucky lawyer who gets the phone call. I know the folks who called me, and they will have started assembling a team that will include your information security folks, the senior leadership folks that might be in the area that's impacted, the lawyers, and that's usually the starting point. And I always start with a couple of different things. One, let's figure out what happened first, or what is happening, right? What do we know? What don't we know? Because there's a lot of stuff that's moving at the time, and the one thing that you don't want to do is A, guess wrong, and B, make it worse. So if it's a mess, let's figure out whether it is a mess, and let's not make the mess a bigger mess by making a mistake in the first 5 minutes of something happening. So
when do you call in the outside forensic consultants?
So-
Like, what can your internal team handle versus when do you need the outside? I have my own thoughts as outside counsel, but.
That's one of the things that I think is going to be, it's going to vary a lot by company, by size of company, and the sophistication of your group. You've got to know what your internal team can do and can't do before something happens, right? You have people on your team that are experts on the technical side, that may have worked for an outside company to begin with. Are they really technical security people that can tell you whether this is red light, yellow light, or orange? And do they know that whether they need help or not? You've got to know who your outside folks are, both outside lawyers and outside technical/forensic experts, for a couple of different reasons. One, you want to know who to call and be able to get in touch with them quickly, and know that they're folks that can get on the ground and be on site and move on site rapidly. You've got to know what levels of expertise those folks have before you call them. There are lots of different companies out there that play in this space or say they play in this space. There are lots of law firms that play in this space and say to play in this space. Some of them might be very capable of handling an incident if what you're talking about was a lost laptop and figuring out who to notify on the back end. It's a lot different if you have an ongoing IT incident, you don't know what's happening or where it's happening and how to contain something that's happening real time, right? So you've got to figure out.
And one of the things we see is a lot of those so many incident response firms will sell to your IT team a retainer. And so your IT team is going to say to you, oh, we got that covered. We have a team on retainer. I would say, show me the engagement letter. Because if that engagement letter is between the IT team and the incident response firm, that's not going to be underprivileged. So step number one is you want to break that engagement, that statement of work, and make sure that you're entering into the contract as between Robert in the general counsel's office and the outside forensic firm. Step number one.
Yeah, so that's if your lawyers are driving it, right, that's what you want to do to maintain the privilege. If you're bringing in an outside law firm, you're going to want the outside law firm to be engaging those service providers, right? And you're going to want to control the workflow, right? The work's going to be done at the direction of the lawyers for the benefit of providing legal advice. You're going to want to make sure that the reporting mechanisms there are structured in a way to maintain the privilege, with a view towards eventual regulatory action or litigation. The other thing that's important from a service provider perspective, and I think it ties back to the insurance statement from earlier, is you've got to really understand before an incident happens what your insurance coverage is, what your notification obligations are, what the retentions under the policies are. The insurance coverage tends not to kick in with $1, and you may have different retentions based on which module you're talking about. I think coverages differ, but there tend to be modules that might cover business interruption, which might have a different notification window than an incident response or a privacy breach, and you've got to know that in advance, and it would be helpful to at least have someone on that team who knows the insurance policy or has summarized it so you know who to notify and when.
And importantly, your insurer will have a team of lawyers, forensic folks, and others to assist. And if you go off and hire your own without checking with your insurer, if you bought the insurance company may not reimburse you for those, or reimburse you completely for those expenses. Heather's firm may be on an approved list for some insurers, but not for others. And then all of a sudden you've incurred a huge expense and it may not be recoverable, or you have a battle you're going to be facing down the road to get those dollars reimbursed.
And some of the carriers will put panel firms too on because of rates and not necessarily because of expertise. And so you have to be very careful because the statements, you might hire a firm that's going to write a notification letter that has all kinds of admissions in it that are going to then support the class action litigation, help you survive an Article 3 challenge, and it creates a nightmare in litigation for companies. So hiring lawyers who know what they're doing to make sure every step they take in the investigation is designed to, and you don't need that in every case, right? You don't need to hit an anthill with a nuclear weapon.
Right.
But if you've got a serious risk of third-party claims, then you need to bring in an experienced counsel or have the experienced in-house team that knows how to manage those risks.
And in order to put your insurers on notice, you don't need to know everything or have a 4-page narrative of what's happening, right? If you've got an incident, you can open a claim with the insurer or file a notice of circumstances that gives you the notice date by saying, hey, I've got something happening, here's the basic facts, we'll update you as it keeps going, right? It's important for two very big reasons. One, it gives you the date, hey, I put you on notice that something was happening as of X. And in some cases, that's the trigger for giving you access to the panel providers, right? Depending on what your policy is, you may be required to use lawyers, forensic folks, even some incident response or PR folks from a panel. Your policy may allow you to go outside, but only if you get approval in advance. And if you go outside that, you may not have coverage at all, or the dollars you incurred may not count towards the retention or be covered in any way, shape, or form. So it's important to know that to begin with, and to have as part of your incident response process right out the gate, something happened, okay, has anybody reached out to our insurance team to make sure that the notification went into the insurers? In some cases, it's not just one insurer. If you have the larger your cyber coverage program is, you're going to have multiple levels of insurers on top of it. So you want to make sure your broker or the primary insurer has notified everybody up the chain just in case it gets to those additional levels of coverage. Back on the point that Heather made about maintaining privilege, one of the reasons you want to make sure that you know who the team is to begin with, and that they're familiar with your incident response process and working with lawyers and outside lawyers and forensic folks, is one thing that happens at, particularly in large organizations, is folks love to communicate widely, and they like to do it.
We really dropped the ball on this one.
Yes,
You're like,
yes.
put that in writing.
Pick up the phone, please pick up the
Phone
phone.
calls, emails, and it takes 2 steps down the chain for an incident that is X to be turned into something that is not X and is completely inaccurate and is causing people to go in 1,000 different directions. So you really have to have a strategy for your, for managing the incident, making sure that the notifications are going to the right folks, whether you're bringing in outside lawyers or not. An internal communication strategy, who needs to know about it and when in terms of managing the incident. If you're looking at any kind of public notification or disclosure, you're gonna have a strategic communications team or PR folks who are gonna need to know what they can say in case they get a call, right? You might be drafting a holding statement or something in case a call comes from outside. These things tend to morph, right? And all of that has to be done and managed through your incident response group and the lawyers, right? To maintain privilege, to keep it coordinated, so that when you end up getting to the ultimate stage of notifying, you've done everything along the way, you've got everything coordinated, the entire package done, so when you ultimately are making a notification to regulators, to the individuals that are impacted, that you've got your internal story straight, you've got your insurance folks on board, you know what's happened, you've checked the regulatory box, and you're prepared to answer the questions that you're going to get, you know, from media folks, from individuals who you've notified, and then the guaranteed regulatory follow-up based on the size of the incident from multiple sets of regulators.
I would say when I get that phone call and I bring in an outside forensic firm and I'm working with the internal team, I focus on 3 things. Step number 1, containment. And I task the forensic firm with saying, I need to know this is contained, that we've stopped the bleeding, and at the end of the day, I want you, outside forensic firm, to give me the certification that this incident has been contained, because that's what the board's gonna want, that's what investors are gonna wanna know. So starting that step, now it's definitely what the regulators are gonna wanna know. Step number 2, I'm asking that forensic firm to map the attacker's activities. When I'm preparing for an incident or preparing for privacy security risks, I always say you gotta follow the data. Figure out where the data comes in, what regulatory regime applies, and that's how you can set the right controls for how to protect that data. In an incident, I say follow the attacker, because breach notification requirements really flow from unauthorized access or acquisition. Well, just because the attacker got into the inbox doesn't mean that that attacker actually opened or accessed or exfiltrated the attachment that was 2,000 emails down in the inbox. So there's a huge difference between, okay, so access the inbox, did they actually access that attachment, which is gonna trigger a notification obligation? If you don't have the right logging turned on for your Office 365 environment or anywhere, then even the forensics team's not gonna be able to give you that information, and you're left with this really difficult decision. Do I notify on everything that's in there, which could be costly and burdensome and dramatically increase my regulatory risk? Or do I assume because it's 2,000 down in the inbox, they didn't get it? So those are all things I'm asking the forensics team to be able to confirm. Map the attacker's activities, because that second bucket of activity really flows into the 3rd step that I'm focused on, which is from the attacker's movements and activity, what notification obligations? And it's not just statutory and regulatory, it's also contractual. So don't forget to look at your contracts and where you may actually have a greater obligation to notify in your contracts than the law even requires. And I would say also focus on 72 hours. 72 hours is the shortest time period for notification in the United States under the NYDFS, under some insurance regulator requirements, but also in different jurisdictions around the world. So if you have a mobile app, for example, that's available generally in the app or the iOS, the Apple Store or Google Play, to be able to download anywhere in the world, Philippines, Turkey, South Korea, I'm gonna roll off a bunch of jurisdictions that actually require notification to those regulators in that jurisdiction within 72 hours. Well, 72 hours from what? I would say 72 hours from the time period that you know individuals in that region are affected. So if you know you have a mobile, now, not all of those laws are necessarily gonna apply to you. Just because someone has downloaded a mobile app in the Philippines does not mean you're subjecting yourself to Philippines law. But that's part of your planning, is to know where are your markets, where might you have a notification obligation, map that in advance, and be ready to make those disclosures.
We're coming to the, close to the end of our time. Are there any other questions from the audience? 1 or 2, we can take 1 or 2. And after our session ends, you can catch us offline out here for other questions. So, any other questions? Yes.
So I represent a lot of small businesses, and I'm usually their first call, and I'm not an expert in any of these areas, but it sounds to me like the first inquiry should be potential insurance coverage and firms that are allowed to be retained and then put your team together? Because most of these businesses do not have an internal team that's set up, you know, all the sophisticated.
Well, that's great marketing activity for you then. Go out and sell that proactive service. Be like, here's 6 steps to get
I
ready.
do not profess to be an expert, and my mind is just spinning right now about what to advise my clients and what to do if I get that first call.
I think the insurance notification is important. I think the practical first step, and this gets back to Heather's, her 3 steps in terms of bringing in the forensic team and following the data. One of the things that they are going to need in order to do that investigation and figure out what happens is they may need a bunch of information internally that you want to make sure you don't step on in the process of investigating it, right? In order to follow the data and the attacker's activity, you're going to need log files, right? So you want to make sure your IT team isn't overwriting the
Preserve
logs
the
as they're
evidence.
doing this, right? They may need to image, if they think there's an issue with a particular computer, you've got to make sure one of your folks can get out there and image that device before something gets overwritten in their process of containing it, right? So you've got to, I think the first thing is to make sure that you've got the right group, you've contained it, you make sure you preserve the evidence, so when you do bring in the forensic team and the outside folks, they actually have the information to figure out whether it's an issue or not. It's important not just for notification purposes, but sometimes those log files and the information that might be on a device can actually help you. It can let you know that an incident that you thought was happening didn't impact the data, the email inbox issue that Heather was talking about, right? You might be able to show from log files that somebody touched an email box but didn't actually open or get to anything, right? If you overwrite the logs, you may not be able to tell that, right?
Most of your small and medium enterprises, though, are not going to have the
Right,
internal
not gonna do that.
capability. They know IT and they know production, but they don't know forensics and security necessarily. So that the reason you'd want to call the carrier, you want to get the panel and figure out which firms are on that list and approved and bring them in quickly. Because for between $10,000 and $50,000, they can step in and actually do all the cleanup. And if that's going to be covered by your policy, then why not do that?
Advantage of it. But there's also a cultural issue that a lot, and I see this in the cases I mediate involving mid-sized to smaller companies. People are afraid to tell folks, admit, hey, I didn't apply that patch and I may have opened a back door and I didn't really want to tell anybody. As counsel, the best thing you can do is start dealing with those cultural issues, that it's okay to admit that, hey, I might have clicked on that email. Yeah, internally, and your lawyers. I may have clicked on that phishing email, and I might have opened a door, and I might have done something, and all of a sudden, all these strange things are happening. Or the IT folks say, yeah, I really didn't apply the patch, and I know I might have, and there may have been something done here, and now it's exploding on them. So a lot of the mid-sized companies, smaller companies, they need that. They need to understand that it's okay in this environment to take advantage of the resources that have been made available and presented by this panel, both from an insurance perspective, but just generally when dealing with these issues. Because if you can't get over that cultural piece, then I'm going to be sitting there as a mediator asking the question, you didn't do what? You're telling me you just sat, well, how do we deal with that? What? And then the poor IT person, the poor assistant.
That's a private conversation with privilege.
Right, exactly,
Yes.
exactly.
That's helpful. So I just have the last question of what is the role of arbitration and mediation with regulators looking over your shoulder? Peter, I guess you'd be on that.
Well, I'll let Melanie talk about it for Heller, and I can give it on the back end, but go ahead if you want to comment about that from at least from the mediator and arbitrator standpoint. From the arbitration standpoint, just keep in mind that many of these consumer cases, if you, the company, have put an arbitration clause in your agreements that might be applicable to that claim, you're going to be paying for 100% of the cost of arbitration. Most of these clauses, if they're going to be enforced, particularly in California, they require that the respondent company pay 100% of the arbitration costs, including whether it's a one-person panel or a three-person panel, and all the costs relating to the arbitration itself. That includes filing fees and the administration fees. So keep that in mind if you decide you want to include an arbitration clause. You better make sure that you're not shifting the entire cost to yourself. And that may be something that's okay. You want to avoid the cost of litigation and being in court, but keep that in mind, whether it's regulators or it's consumers. make sure you're under applicable law, you're not going to end up paying for 100% of the cost.
Okay, so the motto is, no, be afraid, be very afraid, but this is what that's all here, and my thanks to the panel for its presentation.